town official destroying a small business over a personal grudge, a get-out-of-jail-free drug only for government officials, and an American citizen jailed for days with no phone call or lawyer. All that and more on today's IJ Update. Let's get into it. For 24 years, Gene and Debbie Weierbach have run an at-home mechanic shop from their home on a secluded property in Slatington, Pennsylvania. They never received complaints from customers or neighbors, but in 2023, Township Supervisor Dennis Kluseritz urged the Township Zoning Board to investigate the business after a personal falling out between Gene and Kluseritz over work that Gene had done on Kluseritz's cars. After the Weierbachs received a cease and desist letter, they applied for a variance, which they were granted. But Kluseritz then convinced the township to appeal the variance, which the zoning board overturned.
In my situation, I have my disabled son who needs me at home. This is my property. I have 16 acres. I should be allowed to make a living here if I'm not harming anybody or anything.
Now, IJ is representing Gene in a major constitutional lawsuit to vindicate his rights and the rights of small business owners everywhere. Zoning laws should not be weaponized to destroy Americans' livelihoods, especially because one official got mad at you. Gene's video has been widely watched online, and we've received thousands of comments in response. Here are a few. The Weierbachs are the nicest people, hardworking and honest. They don't deserve this. We stand with you, Gene. This really makes me sad for the family. I have an autistic brother and sister. The care that people with special needs children need is unwavering. Shame on the township for their actions. We also had a few questions. What about the people who work from home on the computer? What are we going to do about them? I looked into it and asked IJ's senior attorney, Ari Bargill.
Under any traditional understanding of the power to zone, that's the type of use that ought to be permissible. If you're just sitting at home on your computer, you're engaged in a use that's peaceful and productive and harms nobody. That makes sense because the power to zone is really a product of the police power, which means that the government is only able to restrict uses on the basis of legitimate health and safety justifications. In North Whitehall Township, however, the government is taking the position that it doesn't matter that Gene's use is harmless. Instead, what they're saying is that Gene's use is incompatible with their aesthetic vision for the community. If they're right, what that means is there's really no limitation on the power to zone. That's why IJ is taking the Weierbachs case, to restore the understanding of zoning that the government can regulate if it's doing so in the name of health and safety.
So we made a parody video with AI, but it's worth watching. Similar to something you'd see on SNL, the video is about a fictional pharma drug called Immunity. Here's a sneak peek.
Are you a government official who is tired of feeling congested by the U.S. Constitution? Does getting a warrant give you heartburn? Does free speech make your ears ring? Then ask your doctor about a new drug called Immunity.
I know using AI for videos can turn some people off, but I promise it's a lot of fun. Not so fun is the fact that every example we used about government officials abusing their power is real. You can learn more about our work to combat government immunity at ij.org/PIA. Here are a few comments. First use of AI that I approved wholeheartedly. Take my money! Need me some immunity tablets stat! What if your immunity lasts for more than 4 hours? Deep questions all, but let's try a question we can actually answer. The accountant pulling over vehicles sounded very specific. Does anyone know that story? Indeed I do. Actually, that was a case we appealed to the US Supreme Court. Here's IJ senior attorney Anya Bidwell with the answers.
In 2022, in a case called CSI versus Large, IJ filed an unsuccessful petition for certiorari with the United States Supreme Court on behalf of a Minnesota construction company whose trucks were stopped on a highway for supposedly exceeding the allowed weight. They were stopped by a county engineer whose duties included a lot of things, but they did not include being a traffic cop. Turns out the county engineer had a grudge against the construction company, going back to the days when Mahnomen County contracted with the company to build their roads. The company sued, but immediately ran into qualified immunity. Even though the doctrine was supposedly invented to protect officials exercising their duties, it could still be applied to someone who was acting outside of his clearly delineated authority.
George Redis Jr. is a native Californian who enlisted in the Army while a young man, serving his country in Iraq. In July 2025, George was on his way to his contract security job at a state legal cannabis farm. As he approached, he saw cars parked along the road and people standing around. Eventually, he came to a line of immigration agents blocking the road. He He got out of his car, explaining he was a citizen just trying to get to work. Officers forced George back into his car and approached it, giving contradictory orders. In a moment, George's windows broke from agents pushing on it. He was pepper sprayed and dragged out of the car. George was then held for 3 days, without his family knowing where he was.
I'm naked in like a hospital gown, and it's this yellow room, this concrete yellow room. They just leave the lights on 24/7 from Friday morning to Sunday afternoon to literally the point when I was released. And they never let me shower. They never let me contact my family or talk to an attorney.
George's case isn't about whether the government can enforce immigration laws. It's about whether or not the government has to follow the Constitution, federal law, and its own regulations when it does. Now George has teamed up with us and taken steps to sue the federal government under the Federal Tort Claims Act. Here are a few comments and questions from his video. Thank you for supporting this man and bringing his story to the masses. Mr. Redes is a hero. We owe him a debt of gratitude for committing to pursue these violations of his constitutional rights through the federal court. A long haul, but hopefully worth it in the end. Seems pretty chill for having been kidnapped by the US government for 3 days. Government needs to be held accountable. George really is a chill guy. Aside from his training in the Army, remember, he's from Ventura, California, and you can often find him surfing. At Littlefoot had some questions for an attorney. I have a few questions. Why did George ignore prior commands to turn around and leave? Why did George decide to drive into the opposite lane and inch closer to the line of heavily armed police officers? Was George affiliated with the protesters or rioters? I asked IJ Senior Attorney Patrick Giacomo, and here's his response.
George received conflicting orders from officers, but he was very reluctant to turn around and leave because this was his first time on the day shift, a shift he'd been trying desperately to get on, and he was afraid that if he didn't show up, he would lose the shift or maybe even lose his job. George had no affiliation with protesters or rioters. He didn't even know protests were happening. He was simply on his way to work trying to make an honest living for his family.
Did you know IJ represents ordinary people free of charge as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
Pottstown, Pennsylvania's rental inspection ordinance forced landlords and tenants to open their doors every other year for a government inspection of their homes in search of code violations. Instead of having probable cause that a code violation or dangerous conditions had occurred, officials obtained administrative warrants that essentially gave them free rein to search any rental property wall to wall. After a nearly 8-year battle, Pottstown residents Dottie and Omar Rivera and their landlord Steve Camberd finally won. If the government wants to search your home, it needs a warrant based on real reasons to suspect something is wrong. You don't lose that protection because you rent your home. IJ client Lita Mox of Becker, Minnesota, loves horses. She has a bachelor's degree in equine science, is an expert in horse massage, and has taught it for years. But the state of Minnesota didn't care. To teach horse massage, the state forced Lita to become licensed, complete a 30-page application, pay exorbitant fees up front, and then annually to maintain her license, and furnish the state with a great deal of information, most of which is completely inapplicable to her small business. The state even wanted to review Lita's curriculum, even though no one at the Office of Higher Education knows anything about equine massage. A federal court just ruled that the state did not offer any evidence that Minnesota's law advances at least important governmental interests and does not burden substantially more speech than is necessary. Courts rarely side with business owners, so this win is a big deal for the First Amendment and teachers around the country. For our final update, we just launched a new case in Miami, Florida. Imagine, you want to renovate your house to add a small addition. The government approves, but in return, demands you give up half your front yard. This actually happened to Chad Troush, a Navy veteran who wanted to expand his home due to his growing family. After we took on his case, Miami waived the request, but we found out that Miami routinely subjects land use permits to this demand. Miami's demands violate the takings clause of the U.S. Constitution, which says that the government must pay you just compensation if it wants to take your private property. It can't make you hand over your land for free in order to get a needed permit. To protect the rights of all Miami property owners, we teamed up with Chad and are now taking the city of Miami to court. Don't forget to like, subscribe, and become a monthly donor at ij.org/monthly. Thanks for tuning in.